All rise.
Thank you, my Lord. Can I take up the invitation from Lord Mance to clarify our position on Section 3, subsection 4 of the Race Relations Act, which the Court will find at Volume 9, tab 73. Section 3, subsection 4.
I don't think it's volume 9, it's volume...
Volume 9.
Yes, it is. Big one. Yes.
It's page 3 of tab number 73, section 3, subsection 4. A comparison of the case of a person of a particular racial group with that of a person not of that group under section 1.1 must be such that the relevant circumstances in the one case are the same or not materially different in the other. And the case law establishes that the question whether the claimant suffered less favourable treatment is often interlinked with the question, was the treatment on the ground of race or sex or other prohibited ground? They're not separate questions in all cases, particularly in difficult cases, and the authority for that, there are many authorities, but perhaps the best is the speech of Lord Nichols in Shamoon, which is volume 7, tab 67. Shamoon and the Chief Constable of the RUC. And if I could invite the court, please, to go to page 340, paragraph 7, where Lord Nichols says, in deciding a discrimination claim, page 340 of tab 67. Paragraph 7, second line, in deciding a discrimination claim, one of the matters tribunals have to consider is whether the statutory definition of discrimination has been satisfied. When the claim is based on direct discrimination, in practice, tribunals in their decisions normally consider first whether the claimant received less favourable treatment than the comparator, and secondly, whether the less favourable treatment was on the relevant proscribed grounds. Tribunals proceed to consider the reason why issue only if the less favourable treatment issue is resolved in favour of the complainant. Thus, the less favourable treatment issue is treated as a threshold. No doubt there are cases where it's convenient and helpful to adopt this two-step approach to what is essentially a single question. Did the claimant on the prescribed ground receive less favourable treatment than others? But especially where the identity of the relevant comparator is a matter of dispute, the sequential analysis may give rise to needless problems. Sometimes the less favourable treatment issue cannot be resolved without at the same time deciding the reason why issue. The two issues are intertwined, and there's a lot more detail on that in paragraphs 11 and 12, but it is amplification. And there are many cases where that is so. To give one other example, which is not in the bundle, the MacDonald case, the case about the less favourable treatment of homosexuals. The claimants argue, my Lord Hope was a member of the appellate committee, and my Lord Roger. The claimants argued that but for their sex, they would have been treated more favourably in that they would not have been penalised by reason of the sex of their partners. And the committee decided that such an analysis could not be accepted. And my Lord Roger, paragraph 154, explained it was necessary to look at all the relevant circumstances in deciding what was the ground, and my Lord would hope also paragraph 65. It's 2003 ICR, Industrial Cases Reports, 937. If the committee wants copies, we have them, but perhaps the citation will suffice. Now, in this case, we do present our case by reference, as my Lord Mance indicated. We do present our case in part by reference to section 3, subsection 4. If it's necessary to do so, we say that because he is not Jewish under the religious criteria stated by the chief rabbi, M's relevant circumstances are not the same. They're materially different from those of children who do receive priority under the oversubscription criteria. So we do say that, but I accept, if pushed, and I will be pushed, I accept that that cannot be a freestanding point separate from the points I've made already, because I would have to accept that if the true analysis of this case is that the circumstances are in truth ethnic considerations, they are based on ethnicity, then plainly they cannot be, the distinction cannot be a relevant one for the purposes of section 3.4. So it does come to the same thing.
That's the basic point, isn't
Yes.
it? You can't justify race discrimination by saying the races are different.
Precisely, and I don't seek to do so. I hope I make that clear.
Yeah.
What I do...
There's no definition of relevant circumstances.
No, that's a matter for the court,
Right.
by reference to the facts of any case. What I do say, however, is that when this court is asking itself the question whether or not in truth the ground of the distinction between M and the children who do qualify is in truth ethnic origins, or, as we say, religion, it helps us to establish, for the purposes of section 3, subsection 4, that the relevant circumstances are different and are not ethnic considerations, to point to Parliament's own recognition in the 2006 Act that faith schools may give priority to children by reference to religious considerations. That's how I put it. But I'm not seeking to persuade the court that if my analysis is wrong, and this is in truth an ethnic distinction, I can get home by relying on section 3.4. I hope that answers my Lord Mance's helpful question just before the lunch adjourned. I was dealing with dissent, and I've made my submission that dissent in my submission adds nothing to the analysis. It is still a religious distinction and not an ethnic one, for all the reasons that I sought to identify this morning, that we're simply not concerned, the Chief Rabbi is simply not concerned with a person's ethnic origins. For good measure, I add, although it is not a necessary part of my case, as I indicated in answer to my Lord Phillips this morning, I do add, however, that a person may satisfy the criterion of being Jewish as a matter of orthodox religious law by conversion as well as by dissent, and the evidence establishes very clearly that conversion does not depend at all on your ethnic origins. They are completely irrelevant to whether you would be welcomed as a convert. To be welcomed as a convert, you must satisfy purely religious conditions. And that there exists a conversion route confirms in my submission that the difference in treatment of which M complains is not based on ethnic origin, it is based on religious law. The only reason why the mother's conversion does not suffice in this case is a purely religious reason. The conversion was by a rabbi not recognized by the chief rabbi.
And the process of conversion doesn't give you any priority or preference because of your ethnic background?
The process of conversion simply, if the conversion is validly carried out for religious law purposes, makes you a Jew like any other, for religious purposes. There's no distinction thereafter. Once you are admitted, once you are accepted to be Jewish, you've satisfied the test, you are a Jew like any other. Something relied against us in relation to dissent is the definition of racial discrimination in the UN Convention. May I deal with that dimension of the case? The UN Convention on the Elimination of All Forms of Race Discrimination, which this country has ratified, covers distinctions based on dissent. This is volume 13. Volume 13 at tab number 88. And your lordships will find there the UN Convention. And if your lordships would turn over to page 2, your lordships will see Article 1. In this convention, the term racial discrimination shall mean any distinction, exclusion, restriction or preference based on colour, race, colour, descent, which is emphasised by E and it's emphasised by the Commission, or national or ethnic origin, which has the purpose or effect of nullifying or impairing recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms. So dissent is specifically there referred to. This is a curious instrument because if the court will then look at Article 5 on page 3, one sees in compliance with the fundamental obligations laid down in Article 2, state parties undertake to prohibit and to eliminate racial discrimination in all its forms and to guarantee the right of everyone, without distinction as to race, colour, national or ethnic origin, to equality before the law, notably in the enjoyment of the following rights. And significant by its omission is dissent from the substantive Article 5. There's no explanation for that. The commentaries draw attention to this, the drafting of Article 5 being different from Article 1. The Travo, and I rely for this purpose on the extracts of the book, which I won't take the court to, but they're at volume 17, page, tab number 131, a book by Mr. David Keane of Brunel University, volume 17, tab 131, pages 227 to 232. He draws attention to the fact that the Travo show that this concept of dissent was introduced into the draft of Article 1 as a result of an amendment proposed by the State of India, who gave no explanation on the record as to why this amendment was being introduced. But there is support for the understanding that the reference to dissent in Article 1 was intended to refer in particular to caste systems to the problem of discrimination by reference to caste and analogous criteria which define your rights in a society. And one sees this in particular still at volume 13 at tab 92, which is the general recommendation of the general recommendation on the Convention by the Human Rights Committee. And I draw attention simply on the second page of this general recommendation to what appears near the foot of the page, measures of a general nature. A, steps to identify those dissent-based communities under their jurisdiction who suffer from discrimination, especially on the basis of caste, analogous systems of inherited status, whose existence may be recognised on the basis of various factors, including some or all of the following: inability or restricted ability to alter inherited status, socially enforced restrictions on marriage outside the community, private and public segregation, including in housing and education, access to public spaces, places of worship, public sources of food and water, etc., etc., and untouchability in the final line. And the question remains whether or not any of this was really intended to cover distinctions based on religious fundamental principles, the concepts of a particular religion and how it deals with defining its own members. And we finally, under this head, draw attention to a decision of the UN Committee on the elimination of race discrimination applying this same convention. It's at volume 1 of the authorities. And it's at tab number 5. This is the AWRAP case and Denmark. This is a case, volume 1, tab 5, where the committee was considering a complaint about the decision of the Danish police not to investigate critical statements which this committee found to be offensive. That's their word at paragraph 6.5 on page 8. Critical statements which they said were offensive, made by a member of the Danish Parliament about Muslims. And the court will see, I won't read them out, but the court will see on page 3 what this member of the Danish Parliament had said at paragraphs 2.3, 2.4 and 2.5. And the petitioner who knew about these statements made in the Danish Parliament was aggrieved by the content of these statements, and he was aggrieved that the police had declined to investigate the matter and bring any prosecution. It was said this was a breach by Denmark of its obligations under the UN Convention. And the committee rejected the complaint at page 7, and they rejected it because the statements which caused offence were focused on religion and not on other matters. If one would go, please, if the court would go to page 7, paragraph 6.2, the committee notes the state party's objection that the claims fall outside the scope of the convention because the statements in question are directed at persons of a particular religion or religious group and not at persons of a particular race, colour, descent or national or ethnic origin. It takes note of the petitioner's contention that the statements were aimed at persons of Muslim or Arab background. The committee observes, however, that the impugned statements specifically refer to the Quran, to Islam and to Muslims in general, without any reference whatever to any race, colour, descent or national or ethnic origin. While the elements of the case file do not allow the committee to analyse and ascertain the intention of the impugned statements, it remains that no specific national or ethnic groups were directly targeted as such by these oral statements as reported and printed. In fact, the committee notes that the Muslims currently living in the state party are of heterogeneous origin. They originate from at least 15 different countries. They are of diverse national and ethnic origins. They consist of non-citizens and Danish citizens, including Danish converts. Now, all of that can equally accurately be said of those who are benefited by the oversubscription criteria which are applied by JFS and which are applied by reference to the criteria of Jewish religious law which the chief rabbi applies. 6.3, the committee recognises the importance of the interface between race and religion, considers it would be competent to consider a claim of double discrimination on the basis of religion and another ground specifically provided for in Article 1, including national or ethnic origin. However, this is not the case in the current petition, which exclusively relates to discrimination on religious grounds. The committee recalls the Convention does not cover discrimination based on religion alone, and that Islam is not a religion practiced solely by a particular group which could otherwise be identified by its race, colour, descent or national ethnic origin. The travaux préparatoires reveal that the Third Committee of the General Assembly rejected the proposal to include racial discrimination and religious intolerance in a single instrument, and decided in the Convention to focus exclusively on racial discrimination. It is unquestionable, therefore, that discrimination, this is the point, based exclusively on religious grounds was not intended to fall within the purview of the Convention. And at 6.5, they recognise how offensive the statements were. And we rely on all of that. That's what I wanted to say on dissent. I say it takes the matter no further forward. The question remains, was the chief rabbi or was he not adopting a criterion which distinguishes between people on the basis of their religion, as we submit, or on the basis of their ethnic origins? And he is simply not concerned with their ethnic origins, whether it be Italian, whether it be Jewish, whether it be anything else. He's concerned only with the application of a religious test. The second point I've dealt with already, that's the second point that he emphasises, where he emphasises that we are, as he puts it, impermissibly arguing that we have a good motive for the less favourable treatment. And I've dealt with that already. That's not my case. I do not submit that less favourable treatment on the grounds of a person's ethnicity can be excused by a good motive. The third point that he emphasises, and emphasises correctly, is that the school gives priority to many pupils whose families have no Jewish faith and no Jewish practice. We make 2 points in response. Our first response is that there is a very good reason why the JFS oversubscription criteria do include non-practicing as well as practicing Jews. And I'll show the court, when I come to indirect race discrimination, that the school wants to educate, the governors want to educate, they want to give priority to those children who the chief rabbi recognises to be Jewish, whether they are practicing or not. And the religious obligation, as I shall show the court, is to give to Jewish children, those recognised by the chief rabbi to be Jewish, an education that explains to them their religion in the hope that they will be persons who will come to practice their religion, whether they do so or not at the moment. But I'll come to that, if I may, under indirect discrimination. But the other response that I make on this point to what is said on behalf of E is that it is plain in our submission that Parliament has recognised that less favourable treatment on the grounds of religion covers both less favourable treatment on the ground of what a person believes or what a person practices, and also less favourable treatment on the basis of the religion to which they belong. And I say that because that's what the Equality Act says. If I could invite, please, the court back to volume 9, tab 71. Can I remind the court that in the Equality Act 2006, volume 9, tab 71, section 45, this is on page 33, my lords and my ladies, page 33, section 45.1 defines direct discrimination, and 45.2 expressly states that a reference to a person's religion or belief includes a reference to a religion or belief to which he is thought to belong or subscribe. And my Lord Lord Kerr made the point this morning, you subscribe to a belief and you can belong to a religion. And therefore, if I treat B less favourably because I believe that B belongs to the Jewish religion or indeed any other religion, or because I believe that he does not belong, then I am discriminating on religious grounds for the purposes of this Act, irrespective of what religious beliefs B may or may not have, or indeed irrespective of what religious beliefs I think B may or may not have. And that must be right in principle. It would severely undermine this legislation if a defendant could say, true, I'm treating a person less favourably on religious grounds, but I'm not concerned with what they believe or what they do. I'm concerned with the religion with which they are associated.
Isn't Section 45.2 actually dealing with situations where the alleged discriminator is under a mistake? I mean, you're extending it to cover a situation where the alleged discriminator may assert and believe that someone is a member of a religion which, in fact, they don't subscribe to at all, and which the discriminator knows that they themselves wouldn't subscribe to.
Yes. Well, all I'm seeking to establish is that 45.2 is in general terms, and it would be surprising, given the contents of 45.2, if it were open to the alleged discriminator to say, in relation to religious discrimination under the Equality Act, I'm not concerned with the... I have no view on the beliefs or practice of X, the victim. I'm only concerned with the fact, for example, that he pays a subscription to his local church or mosque or whatever, or synagogue. And therefore it cannot be confined, in my submission, it cannot be confined, religious discrimination, to cases where it can be shown that the alleged discriminator had some view about the practice or belief of the victim. That would undermine this very substantially in my respectful submission. Now, our complaint here is that the Court of Appeal, and indeed in E's printed case, are wrongly seeking to narrow the concept of religion for the purposes of the Equality Act to matters of belief and practice. And we do respectfully submit that that would be a most inappropriate limitation to adopt in the context in particular of Judaism, where, as the court has seen, the religion, not merely Orthodox Judaism, but liberal Judaism, Reform Judaism, and Masorti Judaism, all define those who belong, to use the concept in 45.2, by reference not to belief or practice, but by reference to status. And it would be very surprising indeed, in my respectful submission, if Parliament had intended to exclude these aspects, these fundamental aspects of Judaism from the scope of the Equality Act. Those were the points I wanted to make in relation to direct discrimination in answer to the printed case of the respondent E. To sum up on direct discrimination, our case, as I've said, is a very simple one. E is not in truth complaining about less favourable treatment on racial grounds, that is, on the grounds of his ethnic origins or his perceived ethnic origins, perceived, that is, by the chief rabbi. He is complaining about less favourable treatment which is on the grounds of religion. It is on the grounds of the content and application of the basic religious laws of Judaism. And this case arises in a curious context because E wants JFS to continue to give priority to Jews. There's no dispute between JFS and E, the father, that priority should be given in the oversubscription criteria to Jews. The dispute between the parties is about how the school should identify who falls within the protected category of being Jewish. That's the only dispute between us. It's a very important dispute, but it's not a dispute about whether it's right or wrong for a faith school to give priority to a category broadly understood as Jewish children. And I say, on behalf of JFS, that once one identifies that that is the dispute, and it is, the school is perfectly entitled on religious grounds, because the dispute is about who should fall within the preferred category. The school is perfectly entitled, given its instrument of government, to follow the religious views of the chief rabbi on a religious issue, which unhappily for M excludes him for religious reasons from the preferred group. That is our case on direct race discrimination. May I turn, my lords and my lady, because I noticed the time and I've still got to deal with indirect discrimination. Happy to answer any other questions, of course, the court may have, but I was proposing then to move to indirect race discrimination. I note the parties are agreed that a policy or practice cannot both be direct discrimination under the 1976 Act and indirect discrimination. And the arguments on indirect discrimination, of course, proceed on the basis that there is no direct discrimination. If I failed so far, that is the end of the case, this is an unlawful policy. If I have succeeded so far, I have succeeded because the court will have been persuaded that the adverse treatment, the less favourable treatment of M, was not on the ground of his or his mother's ethnic origins. It was on the ground of his religion as determined by the chief rabbi. Now, the concept of indirect discrimination, as the court well knows, is a concept designed to address policies or practices which have a disparate impact on a particular racial group, a group that is defined by reference to ethnic origins. And the question then, the crucial question in the context of indirect discrimination, is whether the defendant can show, whether JFS can show, that the policy is nonetheless a legitimate one. It pursues a legitimate aim and does so in a proportionate manner. Those are the essential criteria. And can I remind the court of the legal concepts we're dealing with in the 1976 Act? It's volume 9 of the authorities, tab 73, if I could take the court back to that because I didn't read it this morning. We're in section 1. The position was, under the original 1976 Act, that indirect discrimination was defined in 11B. But we now have added into section 1, the court may think not in a particularly helpful way, a supplementary definition of indirect race discrimination in section 1A, which is the consequence of the European directive. Section 1A was introduced by the regulations, and I don't invite the court to turn it up, but they're at volume 12, tab 80, which implements the directive at volume 11, tab 75. And the parties are agreed that one should focus on 1A, not least because section 1 big C over the page tells us that 1A takes priority over 1B. It is logically possible that the case may fail under 1A and yet still succeed under 1b, but no one here is suggesting that this is such a case. So, therefore, we can focus on 1 big A, and 1 big A tells us that a person also discriminates against another if in any circumstances relevant for the purposes of any provision referred to in subsection 1b, and we are in that territory, he applies to that other a provision, criterion or practice which he applies or would apply equally to persons not of the same race or ethnic or national origins as that other, but A, puts or would put persons of the same race or ethnic or national origins as that other at a particular disadvantage when compared with other persons, B, which puts or would put that other, that's the complainant, at that disadvantage, and C, which he, that's the defendant, cannot show to be a proportionate means of achieving a legitimate aim. Now, in our printed case, we have suggested, it's paragraph 61 to 66, which I don't invite the court to turn up, we have presented an argument as to why, in this case, the criteria in 1 big A, little a and b are not satisfied. But I don't want to take time on developing that argument in oral argument. I maintain it but I'm not going to take time, given the limited time available. I much prefer in oral argument to focus on seeking to persuade the court that we can show under section 1 big A, little c, that the policy which is impugned, that is the oversubscription policy, is a proportionate means of achieving a legitimate aim. And that's what I turn to. Now, we say that there are essentially three questions under little c properly analysed. The first question is whether there is a legitimate aim. Does the oversubscription policy satisfy a legitimate aim? The second question is whether the defendant, JFS, has adopted a proportionate means of achieving it. But there's also a third question, and there's a third question because the Court of Appeal found against us, not on the basis of legitimacy or proportionality considered on their merits. The Court of Appeal found against us because it said that the oversubscription criteria are, quote, explicitly related to ethnicity and therefore cannot be legitimate or proportionate. And that's not surprising because they had already found that there was direct race discrimination. But I need to deal with that, and I will deal with it. But may I deal with three issues in that order: legitimacy, proportionality, and the allegation this is all explicitly related to ethnicity. Legitimacy. Our case is that it is a legitimate aim. It is a legitimate aim for JFS as a faith school, when oversubscribed as it is, to give preference to those children who are members of the religion as defined by the religious authority which it recognises. That's the chief rabbi. And the reason it's legitimate is because it's a legitimate aim for an oversubscribed faith school to give priority, and we're talking about priority in allocating places to children who are recognised by the religious authority to be Jewish, so that they may benefit from an education which will teach them about their religion. Those who are excluded are simply not Jewish for the purposes of the religious authority recognised by the school as a faith school. Now, may I take this legitimate aim in stages? The starting point, and the court has seen it this morning, is that Parliament has recognised by section 50 of the Equality Act that it is legitimate to allow a faith school to discriminate in oversubscription criteria on religious grounds in deciding which pupils to admit. Parliament has recognised that at the very least. And if the direct discrimination claim fails, and I've addressed my arguments on why it should fail, it is because this faith school is discriminating on religious grounds in deciding who to admit under its oversubscription criteria. I then say it is...
Would it make any difference to your argument if Parliament had not done that? If there had been nothing like the Equalities Act, nothing legislating to protect against religious discrimination, would it make any difference to your argument? You'd still say it was legitimate, wouldn't you?
Your ladyship is
For exactly
right.
the same reasons.
Your ladyship is correct. But this, I submit, this helps me if the position is otherwise unclear, because to the extent that it is said against me that the aim is not a legitimate one, it must surely assist for me to demonstrate that Parliament itself, when legislating to prohibit religious discrimination, has expressly recognised an exception to allow faith schools to discriminate on religious grounds in relation to oversubscription criteria. So the answer is yes, but.
But, I mean, again, you come back to the construction of Section 45. On the face of it, it's focusing on somebody's actual religion or belief, or religion or belief which they are thought actually themselves to have.
Or to belong.
Well,
That's
that's the critical question. I mean, is Parliament contemplating a situation where a person, him or herself, might not and think that they were a member of the religion, might assert completely the contrary?
Yes.
But nonetheless, by another test, here the Orthodox Jewish, they would be regarded as irreversibly and irremediably, or inevitably, Jewish.
Yes. I understand your Lordship's question. That's the next issue. Given that it's a legitimate aim for the faith school to discriminate on religious grounds in applying oversubscription criteria, is it legitimate for those oversubscription criteria to be defined by reference not to the beliefs or practice of the child, but by reference to whether the child is a member of that religion? That's the next question. Is that legitimate? And I have to satisfy the court that that is also legitimate. And I have two factors I draw attention to in relation to legitimacy. The first, and we've been over this already, is the content of Section 45, subsection 2 of the 2006 Act, which does say that religion or belief includes a reference to a religion or belief to which he is thought to belong or subscribe. And I say that is a recognition by Parliament that it is legitimate in this context for the faith school to have regard to whether the child does or does not belong to the relevant religion. But I also rely, if your Lordship isn't satisfied by that, I also rely on the school admissions code, which I showed the court this morning, which of course is not a document that is other than the policy of the Secretary of State, but it is striking that the code is a document with which the governing, which is now a binding document.
Just 1285.
It's not 84.3. Yes, Section 84.3 of the 1998 Act now requires the governing body to comply to act in accordance with any relevant provisions of the code. That's Section 84.3, which is volume 10, page 73. It is true that that has been strengthened, that requirement, in recent years. But at the very least, the code is a document issued on behalf of the Secretary of State, indicating from the Secretary of State's point of view what is regarded as acceptable. And it's very clear from the repeated references that I took the court through this morning, volume 12, tab 85, that from the Secretary of State's point of view, it is perfectly legitimate for the oversubscribed faith school to adopt a criterion either based on membership of the religion or a criterion based on practice. And there's some evidence on this if it assists the court. The evidence is the witness statement of Ms. O'Sullivan on behalf of the Secretary of State. She deals with this matter. And I don't want to steal Mr. Linden's thunder, but could I just indicate the position? It's Appendix Part 2, page 551. The court will find the witness statement of Ms. O'Sullivan, and she addresses this question starting at page 557, paragraph 21. She explains in general terms that the presence of faith schools in the maintained sector adds to the diversity of provision. Page 557, paragraph 21, means that parents have greater choice when considering the sort of education they want for their children. Parents who wish their children to be educated in line with the ethos and values of their faith are able to do so without the need to pay fees outside the state sector. Parents want there to be diverse provision. Many parents want a faith-based education for their children. The schools are popular. There's a clear demand, etc., etc. And then over the page, she says at 24, some schools give top priority to members of the faith, i.e. those children who are accepted members of the faith but who have not had to show, or their parents have not had to show, a particular level of religious practice. Other schools prioritise practitioners of the faith. They will therefore require evidence of regular and committed religious practice when deciding whether a child should be offered a place. The majority, she says, of Muslim schools adopt this approach. And then over the page to 560, paragraph 34, she tells the court it is the Secretary of State's view that it is legitimate for faith schools to give priority on admission to any category of pupil, provided they comply with the law. Schools which prioritise members of the faith, her emphasis, without requiring evidence of religious practice, are therefore considered to be acting within the law as reflected in the Code of Practice. Equally so are those who give priority to practitioners of the faith, requiring evidence of a certain level of commitment and religious activity. There are justifications, she says, for both approaches. For example, a school might decide that children who have been born or raised in a faith should have the right to an education amongst children of the same faith, irrespective of whether the child or the parents are active in the religion. The Secretary of State considers it legitimate for parents who are members of faith, however that's defined by the faith, but whose practice of the faith may be limited, to wish to educate their children in line with the ethos and values of the faith. This may, for example, be felt by the family to be an important part of the cultural heritage of the children, especially in today's multicultural society. On the other hand, another school might decide it will give priority to children who practice the faith actively. Other schools consider it's their role to educate the community at large, irrespective of faith. The Secretary of State considers all of these approaches, aims and objectives are valid in a system which values diversity. And I respectfully commend all of that to the court as correct insofar as one is looking at legitimacy. Now, when one comes, therefore, to look at Jewish schools, there is evidence before the court as to why, as a matter of religious principle, Orthodox Jewish schools wish to give priority to those children who are Jewish under Orthodox religious law. And the witness statement is that of Diane Gelly, parts of which the court saw this morning. His witness statement, Diane Gelly, the judge of the Beth Din, the religious court, explains Appendix Part 2 at page 601. Page 601, paragraph 48, it's the final paragraph of his statement. He says, education about the Jewish faith is considered to be, by Orthodox Jews, to be a fundamental religious obligation on all Jews. A person may be Jewish, but the Jewish faith is complex, it's often demanding, and understanding and appreciation of the Jewish faith takes many years to cultivate through learning, debate, and thinking. This is one of the primary purposes of schools such as JFS, which seek to help those who are Jewish or who are undergoing conversion understand, learn about, and follow their faith. And that's the point. It is true, of course, that many of the children who qualify under the oversubscription criteria are not observant. They do not practice their faith. The point is that they are, for the purposes of Jewish religious law, Orthodox Jewish religious law, they are Jewish. And the purpose, as seen by the Chief Rabbi and Diane Gelly, the purpose, I say the Chief Rabbi and Diane Gelly because there's evidence that the Chief Rabbi has approved Diane Gelly's statement. The purpose, primary purpose, one of the primary purposes of JFS is precisely to provide an education to these children who are Jewish as a matter of Orthodox Jewish law so that they can learn about their faith and, from the point of view of Orthodox Judaism, begin to be encouraged to practice it. Yes, I'm grateful. Page 611 is the letter from the office of the Chief Rabbi, where the Chief Rabbi, Sir Jonathan Sachs, or Lord Sachs as he now is, 20 minutes ago, confirms that he's read Diane Gelly's statement with which he concurs.
I imagine that those Roman Catholic schools and possibly those Anglican schools that admit on the basis of baptism would say exactly the same thing.
Your Ladyship's correct. Precisely so. Precisely so. Yeah. And that's the purpose, a perfectly legitimate purpose of a faith school. Nothing to be ashamed of, nothing to apologise for, and it is perfectly legitimate for the faith school to adopt the approach. We wish to have the opportunity, take the opportunity, to inspire, to educate children of the faith, whether they are practising it or not, whether they're observant or not, whether they believe or not, in the hope, in the expectation that they will be inspired to become observant members of their religion. So I say this is a legitimate aim of the faith school.
Lord Panic, all of these submissions are based on the implicit concession that there is indirect discrimination and that what you say, the religious discrimination is benefiting disproportionately
It is
an ethnic group. Now, as I understand it, the ethnic group you would identify is not coextensive with those who are actually receiving the benefit, but there's a very big overlap.
Yes, I'm, for the purpose of this argument, yes. I'm accepting that even though the religious criterion applied by the Chief Rabbi does not, on analysis, is not on analysis a ground which distinguishes people by reference to their ethnic origin, it will nevertheless be true that a very high proportion of those who do qualify are going to be children who have Jewish ethnic origins. They are much more likely to satisfy the religious test than those who don't have Jewish ethnic origins. And therefore, we are in the territory of prima facie indirect discrimination. However, I have advanced an argument in the printed case that we do not even get to that stage, but I didn't want to take time on that. But Your Lordship's correct.
But I think your argument would be precisely the same if it so happened that the two groups were absolutely coextensive.
Yes,
but
right? Then it would be said against me that this is direct discrimination, as it was in the James and Eastleigh case, where the court will remember that one had the situation where the swimming pool of the local authority says that there's a higher charge for admission for the man age. The admission charge depends on whether you're over pensionable age, and therefore the man age 61 pays, and the woman age 61 does not. And the House divided by 3 votes to 2 on whether that was direct discrimination. And I would have to accept, I think, that if the criterion that is applied by the Chief Rabbi, in fact, puts all people of one ethnic origin on one side and all people of another ethnic origin on another side, then the case for direct discrimination will be much stronger. But that's plainly not the case here. At most, it can be said against me, and this is the strength of the case against me, that the religious criterion tends to advantage those who have Jewish ethnic origins as identified under Mandler and Dowley. But that cannot be sufficient to establish direct discrimination, which cannot be justified, because you have then destroyed the distinction between direct discrimination and indirect discrimination. And precisely because direct discrimination cannot, in principle, ever be justified, there may be statutory exemptions, but there's no test of justification, I say courts should be careful not to expand the concept of direct discrimination further than it legitimately should go. That was a long answer, but the answer is yes. I apologise for it. So I say that the policy is a legitimate one. The next question is whether...
I'm sorry, if you're going to leave the question of legitimate policy, yes. It seems clear from your argument that membership of a faith, certainly in the Orthodox Jewish context, can be an involuntary condition. And you are an Orthodox Jew because you're the son or daughter of an Orthodox Jew. If one has a child of an Orthodox Jewish family, and the family professes no belief whatever, and doesn't wish to avail of the ethos of the school at all, but wishes to send the child to JFS because of its academic excellence, is it a legitimate aim to prefer that child over a child, let us say, of a Reformed Jewish family who would wish to avail of the culture of the school?
In my submission, yes, because the child, whatever the views of the parents as to the desirability of promoting Judaism in their child, is, according to Orthodox Jewish law, a Jewish child. And it is legitimate, in my submission, for the school to adopt the approach that it wishes to give priority to children who are Jewish, so that the opportunity can be taken to educate them about their own religion, in the hope, belief, that notwithstanding the disinterest of the parents and the child in following their religion, they will be inspired to do so. And the reality is that any other oversubscription criterion means that you give the place rather to a child who is not, according to the chief rabbi, who is the appropriate religious authority of this school, see the instrument of government. you give the place rather to a child who is not Jewish according to the religious laws of the governing religious authority.
Well, the decision of the chief rabbi, therefore, is the essential underpinning of the legitimacy of the
Yes. Yes, but he is, under the instrument of government, he is the religious authority, and the code makes it very clear indeed that determinations as to who falls properly within the scope of the faith in this context must be left to the religious authorities.
I quite understand that, but he's defining not only who is an Orthodox Jew, but he's defining the legitimacy of the aim.
Well, the chief rabbi is not defining the legitimacy of the aim. The court does that. The court decides what is legitimate. My submission is that it is legitimate for an oversubscribed school. That's what we're talking about. It has to select between different pupils. Who is going to get priority? It's legitimate for the school to say that we are going to follow the ruling of the chief rabbi on who is a member of our faith for this purpose and give priority to those children. The school recognises, of course, that the consequence of that will be that some of the children who have this priority are children who are either not interested in their faith or they are children who are actively hostile to the faith. But the legitimacy of the aim is indicated by the religious material I've shown the court and the purpose of the faith school. That the school seeks to have the opportunity to educate children who are members of the faith, whether they're practicing or not, in the hope and expectation that exposing them to the religious principles as part of the education will inspire them, will make them observant Jews rather than non-observant Jews. That's the theory of this. Why, says the school, give priority instead to someone who, according to the chief rabbi, the religious authority, is not, and I realise how hard this is for M, is not Jewish according to the chief rabbi. That's the point. So I say the aim...
Would you accept, Lord Banning, that the force of that last point is a bit diminished, although you'd say it still stands, that for the child from a completely non-observant home, who, like M in this case, well, not like M individually in this case, is very committed indeed to Judaism, is going to be put in because other parts of your evidence emphasize the huge importance of the Jewish home and of ritual and observance and prayer together in the home, maybe in quite an anxious dilemma as how he's brought up at home and how he's brought up at school.
Well, the chief rabbi would say, and the religious authorities would say, that if the child, who is a Jewish child, does not have the benefit of the Jewish upbringing at home, it is even more important that that Jewish child, Jewish according to Orthodox religious law, is a child who has the opportunity at the school to be introduced to the principles of Judaism and to thereby be allowed, as the child develops and gets older, to decide for himself on the basis of knowledge whether he does or she does wish to become an observant Jew. But I take your lordship's point. It is more difficult.
I mean, the chief rabbi decides yes or no, is this child an Orthodox Jew by reference to Jewish law. The oversubscription criteria he is consulted about, but the decision as to what the oversubscription criteria are is not actually his.
No, the lordship's correct. The school has decided under the instrument of government what the oversubscription criteria should be. They're not surprising oversubscription criteria, given that we are told this is an Orthodox Jewish school in the sense that the foundation governors, who are a majority, are appointed by the United Synagogue. But your lordship's correct. The chief rabbi does not decide the oversubscription criteria. I say that it is legitimate for the school as a faith school with the instrument of government that it has to decide that it will adopt oversubscription criteria which give priority to those children who are Jewish according to Orthodox Jewish law. And that is a legitimate aim for the reasons I've sought to identify, and because the stark choice, if you do not have those oversubscription criteria, is to give priority, even as to one place, to a child who is not recognised by the chief rabbi to be Jewish, and to exclude from that same place a child who is recognised by the chief rabbi to be Jewish. And from the point of religious law, ethnically Jewish, as I have accepted, of course, M is, the chief rabbi does not recognise, as the religious authority to whom the school defers, the chief rabbi simply does not recognise M to be Jewish. That is the religious fact that is at the background of this unhappy dispute.
But the incidental effect of one of these children who comes from a non-observant home, let us say, going to this school and being exposed to all the teaching and so on, may be to weld them into the sort of Jewish cultural community. But as I understand it, that's not what the chief rabbi is concerned with. He wants them actually to become observant Jews rather than just cultural.
For religious reasons.
For religious reasons.
The chief rabbi's objective is to promote active religious Judaism. He believes, this is all he's concerned, at all stages, the chief rabbi's concern is a religious concern. And the chief rabbi is concerned as best he is able, and the governors believe it's legitimate and proper to follow his lead in this area. His concern, I'm grateful to your lordship, is to promote active Judaism, to encourage persons who are, from his perspective, Jews, to become more observant and believers. And that's a perfectly legitimate aim. No one, in my respectful submission, could seriously dispute, in the context of Section 50 of the Act, that it is legitimate, as Parliament has accepted it is legitimate for faith schools to follow a policy of seeking to promote amongst members of their faith, however defined, greater religious observance. We're talking about schools, we're talking about education. And the whole point is to open up to those children who are fortunate enough to go to JFS. I say fortunate enough because of its high quality generally, to open up to them the religious dimension that, from a religious perspective, is very valuable. Whether or not they have had access to it at home. So I say this is legitimate. Yes, I'm reminded, I read it to your lordships this morning, I'm grateful, I'm reminded that this is what the instrument of government focuses upon at paragraph 8. It was page 716 of Appendix Part 2. I'll just read the sentence. The school aims to serve its community by providing education of the highest quality within the context of Jewish belief and practice. It encourages the understanding of the meaning of the significance of faith and promotes Jewish values for the experience of all its pupils. So paragraph 8 of the Instrument of Government, I'm grateful, does focus on this. So we say all of this is perfectly legitimate. The next question is whether the school, in seeking to pursue this legitimate aim, is doing so in a proportionate manner. And it's exactly, I say, the same issues arise. This is an Orthodox Jewish school it must be proportionate, given the legitimacy of the aim, it must be proportionate to adopt oversubscription criteria which give priority to those children who are Jewish according to the chief rabbi, whether or not they are religiously observant or their parents are religiously observant. And the suggestion on behalf of E that we should somehow balance, in terms of proportionality, the religious practice or beliefs of particular parents or their children simply misses the point in the context of Judaism, in the context of the chief rabbi recognizing a person as being Jewish, irrespective of belief or observance, and the aim of the school being to promote understanding and awareness in all children who are Orthodox Jews, who are recognised to be Jews in the Orthodox community.
How do you test the proportionality? Is it because you're focusing on what the school does? Is that the way you...
Well, you start with the legitimacy of the aim, and you ask whether the school is implementing that aim, which the court has recognised for the purposes of this argument as being a legitimate one, whether the school is implementing it in a proportionate manner. My point on the facts of this case is that there is no other way of implementing the aim once it has been decided to be legitimate, if it is. Yeah. There's no other way of implementing the legitimate aim without fundamentally undermining it. It's simply not possible, because for each child who is admitted, who is not a Jew according to the chief rabbi, you are denying a place to a child who is a Jew according to the chief rabbi. So I don't accept that there can be any question here of balancing, of doing anything that will not undermine the very aim of the school, the legitimacy of which, for the purposes of this argument, we are assuming.
Lord Planning Councillor, this is a pretty facile question, but I mean, assuming as one is doing oversubscription, I mean, does it follow that hitherto, I mean, while these criteria were in being, every single member of the school was accepted as a Jew by the Orthodox?
Yes.
Yeah.
So that's before this case, yes.
Before this case. And so actually, I mean, the school would be turning away others who actually were Orthodox Jews anyway.
But the factual answer to your Lordship's question is yes, and it follows logically that to adopt any other oversubscription policy, certainly one that will benefit M, because there's no dispute that M is not...
You'll be turning away more.
Yes, and that's a consequence of the fact this is an oversubscribed school. We have every year, we JFS have every year applying to the school more children who are Jewish according to the chief rabbi than we have places for them. That's the position. So I say proportionality can't assist M.
I mean, as between two Orthodox Jews who tick the boxes, then it's the school can apply whatever criteria.
No, the oversubscription policy, I didn't read it out this morning, but the oversubscription policy sets out different levels of priority. It's if one goes back to we're looking at 2007, 2008. If one goes to Appendix Part 2, page 729, priority goes, as I understand it, to children who are in care, then those where there's siblings, and then you apply a test by reference to ability band. It's paragraph 2.
I see,
yeah. So, but that's all within the children who satisfy the test of being Jewish according to the chief rabbi, because there's simply too many of them. There's too many of them for the number of places, so the school has to have further criteria to distinguish between the children who are Jewish, according to the Chief Rabbi.
It does mean that the difference between 1.1 and 1.2 of the policy is purely formal. I won't say cosmetic, but if in every year you've always been oversubscribed.
Yes, but of course there's no guarantee that that will remain
no,
the case, not least because there is another school that opens in September 2010 that no doubt will attract some of the applicants, some of the potential applicants.
Your point, Lord Banning, about a proportionate means of achieving a legitimate aim, gives almost absolute priority to the religious, one might call it proselytizing wish to encourage those who are regarded as Jewish to become active Orthodox Jews. It was found. I was just going to. Can I just put the rest?
Yeah, of course.
It was found by Mr. Justice Mumby that the Jewish Free School hadn't complied with Section 71, which required them to have due regard to the need to eliminate unlawful racial discrimination and to promote equality of opportunity and good relations between persons of different racial groups.
Yes.
How is it possible to say that absolute priority should be given to the religious aim if there's been no assessment of the impact on good relations between persons of different racial groups or the possibility that, or equality of opportunity?
Well, the first answer to your Lordship's question is that Mr. Justice Mumby went on to say, in passages that your Lordship has referred to, that it is absolutely clear that the failure to comply with Section 71 made no difference whatsoever to the content of the oversubscription criteria. He was satisfied that that was the case on all the evidence before him. The Court of Appeal did not base its judgment at all on the Section 71 point. I'm just looking to find it in my notes somewhere. Here we are. Mr. Justice Mumby's findings are paragraphs 213 to 214 of his judgment. And paragraph 214 of his judgment, which the court may wish just to glance at in appendix part 1, and the court will find paragraph 214 at page 78, where his lordship said that in his judgment, this is appendix part 1, page 78, paragraph 214, in his judgment, JFS, despite the good intentions embodied in its race equality policy, despite the work which obviously went into it, has failed to comply in full with the requirements of 71. In the circumstances, he, if he wishes, is entitled to a declaration to that effect, but the breach does not, in his lordship's judgment, entitle him to any other relief, for it is quite idle to imagine that the fullest and most conscientious compliance with Section 71 would have led to any difference either in the crucial part of JFS's admissions policy or its application in M's case. Now, I say that that's a finding he's perfectly entitled to make, and it necessarily follows once one recognises the reason why the oversubscription policy is drafted as it is. And I say further in answer to your Lordship's question, the first part of your Lordship's question, which, as I understood it, was asking me, why give such weight to the religious policy, the religious aim, and give limited no weight to other objectives. Now, the court, if I may respectfully say so, is in a very difficult position here. And I respectfully say that because it is not easy for a court in a context where Parliament has recognised the legitimacy of faith schools and has recognised, if I am right in my earlier submissions, that the aims of JFS are perfectly legitimate, for a court then to weigh the strength of the religious demands or considerations which have led JFS and the Chief Rabbi to adopt this absolutist approach, as my Lord quite properly puts it to me, against other considerations, in particular, what about someone in the position of M? Now, that is a very difficult judgment to make, to weigh and balance a religious consideration against a secular consideration. And I respectfully submit, most respectfully submit, the court should be very slow indeed in a context where Parliament has recognised the legitimacy of faith schools and the legitimacy of oversubscription criteria which are based on faith, and if the court accepts my earlier arguments where the aims of JFS are also legitimate in legal terms, then for the court to say, applying a proportionality test, that these religious considerations are, in the view of the court, not as important as JFS and the Chief Rabbi think they are. That is not saying that the court has no power, far from it, respectfully, but the court should be slow to apply a test of proportionality in that context.
In this context, what was being suggested is that the court should adopt its own weighting for religious criteria, because it would be adopting different religious criteria, but they would still be religious criteria in the court's view.
They would, but it's a sensitive task
yes.
for a court to adopt, say to a faith school which has been recognised by the Secretary of State as a legitimate faith school, in the context of the policy that the Secretary of State has adopted, in the context of the instrument of government, for the court to say that we think different religious criteria are appropriate to those which the religious authority of your religion think are appropriate. I'm not, of course, for a moment suggesting the court has no power. I simply submit that the court will be very, very slow indeed to intervene in that way in a context such as this.
Can I ask, was a weighing exercise ever undertaken, even in the context of this litigation? In other words, what was the basis for Mr. Justice Mumby's finding, or is the position simply that he was satisfied that however odd the results and however bad the relations between persons of different groups that might result, it is irrelevant because the religious consideration is an overwhelming good?
Well, the latter. There's no suggestion of any balancing, unless I'm corrected. There's no suggestion of that, because Mr. Justice Mumby was satisfied that so overriding are the religious considerations as perceived by the Chief Rabbi, to whom the governors allocate this task of applying the test, and they accept that he should be the person who determines the application of the criteria. They think the criteria are appropriate. There's no realistic prospect whatsoever that reconsideration by reference to the Section 71 could make a difference, because Section 71 will simply draw to the attention of the authorities factors that they're well aware of. I mean, they know, because it's a very controversial issue. Of course it is, in the Jewish community. They are well aware that there are boys like M who are religiously observant, who are excluded from this school. And they know perfectly well that there are many children at the school who themselves and from their background are not religiously observant. This is not news. This is the background, the essential background, to the religious problem that the Chief Rabbi has addressed.
Can I just make sure that one thing is out of the way? As far as the policy is concerned, 1.1 deals with the policy where the school is undersubscribed, which has never in living memory happened, as far as I can understand it.
Yes.
But, I mean, it's simply making a virtue of necessity, that policy, isn't it? Because while the school's undersubscribed, it just has to take anyone who wants to come regardless of whether
if it's undersubscribed and there are not enough children who are Jewish according to the chief rabbi, there is no dispute. It must fill up the places. And it must fill it up by definition with children who are not recognised by the chief rabbi to be Jewish. And there are many Jewish schools throughout the country of which that is true. They are not oversubscribed. There's a further reference, if it assists, in the guidance laid down by the chief rabbi more recently. That's after the judgment of the Court of Appeal. It's Appendix Part 2, page 745. I simply direct the Court's attention to this as confirming what I've already said. Page 745, this was what was issued by the chief rabbi following the Court of Appeal's judgment when a new criteria needed to be adopted. I simply refer to the second paragraph on page 745. Until now, the only religious criteria in relation to schools' admission in the event of oversubscription has been that the applicant is halakhically Jewish. That's according to Jewish religious law. Jewish schools were able to give priority to those children who were members of the Jewish faith, that's as defined by Orthodoxy, and through education develop their knowledge, understanding, and practice of the Jewish faith. And that's the point, as understood by the chief rabbi. That is the core of it. And I respectfully submit that any test of proportionality is not going to assist the claimant, E, the father in this case, because any change in the oversubscription criteria will inevitably result in a child winning a place who is not an Orthodox Jew and depriving of that place a child who is. There's no halfway house that exists in this context. That's our case on proportionality. Now, it's no answer to that case for E to emphasise, as he does in his printed case, that there are many children not within the oversubscription criteria who are just as religiously observant as those given priority by the criteria. I've dealt with that already. The answer is that, unhappily for them, they are not Jewish according to the orthodox principles of Judaism. The Court of Appeal, for its part, did not analyse whether there was a legitimate aim, and if so, whether it was applied in a proportionate manner. The Court of Appeal stated, and can I take the Court, please, to paragraph 47 of the Court of Appeal judgment. It's the second part of paragraph 47, the last 5 lines. They tell us it would be an impossible, this is page 17, Lords, of the core volume, part 1. The last 5 lines, they tell us it would be an impossibly artificial exercise to examine the residual legitimacy and proportionality of a policy which would, for this purpose, have to be presumed what we've concluded it's not. That's to say, neither directly discriminatory on racial grounds, nor, if indirectly discriminatory, based on ethnicity. We think it not only unnecessary, but unhelpful for us to attempt this. So the points I've been dealing with so far are, with respect, simply not addressed in the Court of Appeal's judgment. They proceeded rather under indirect discrimination from 2 premises. Their first premise was that the criteria, the oversubscription criteria, were directly discriminatory, which was their finding. Their second premise was that in any event, the oversubscription criteria are, as they put it, explicitly related to ethnicity. One sees this at paragraphs 45 and 46, also on page 17. Can I read those paragraphs? paragraph 45 on page 17, it appears to us that there's no answer to my friend Miss Rose's submission that the element of the admission criteria is explicitly related to ethnicity. Paragraph 45 on page 17. No answer to the submission that the oversubscription criteria is explicitly related to ethnicity and so incapable of constituting or forming part of a legitimate aim. For the United Synagogue, for whom I had previously appeared, I'm recorded as candidly accepting that the criterion is linked to ethnicity. My concession was that the prima facie indirect discrimination must be assumed for this purpose to be satisfied. In other words, one can show a disparate impact. But that is always the case in any case where a question of justification arises, because unless there is that link in the sense of a disparate impact on one ethnic group, you never need to justify. The Secretary of State, Mr. Linden, sought surprisingly, if we may say so, to argue that it's possible under Section 1(1)(a) for a criterion related to ethnicity to be a proportionate means of achieving a legitimate aim. Well, it's the same point, as I understand it. He didn't persist in this argument. In our judgment, they say, an aim of which the purpose or inevitable effect is to make and enforce distinctions based on race or ethnicity cannot be legitimate. Now, of course, if the case against us on direct discrimination, that this distinction, this less favourable treatment, is on grounds of ethnicity, is established, one sees the force of that. But the claimant does not need indirect discrimination unless he has lost on direct discrimination. If he's lost on direct discrimination, he's lost because the criterion is one in truth on the ground of religion and not ethnicity, albeit that there is a disparate impact on persons of a particular ethnic group. And the question then must be a question of justification. And with the greatest of respect to the Court of Appeal, they have erred in their analysis of indirect discrimination by not proceeding to analyse what is the aim, is it legitimate, and is it proportionate. And if all of those questions are decided in our favour, and if we have also succeeded on direct discrimination, we, for our part, would submit that there's nothing left on the facts of this case in the complaint of indirect race discrimination, because the criterion, although it has a disparate impact, is not one that is based on ethnicity. It is based, as I've already submitted, on a religious principle and religious distinctions.
The Court of Appeal's paragraph 46 is talking about two very different situations. I suspect you might not challenge the conclusion if the purpose was to make and enforce distinctions based on race or ethnicity.
Yes.
That would be absolutely on all fours with direct discrimination.
Precisely so. Precisely so.
Inevitable effect is something very different.
Inevitable effect takes us into the category of indirect discrimination, standard indirect discrimination. The ground of distinction is not ethnicity. It's not a sham case where the true ground is ethnicity. You've tried to cover it up in some way, but it has an effect. It has an adverse impact. Question then is whether, nevertheless, the aim is a legitimate one and it is carried out in a proportionate manner. So we respectfully submit, if the court finds in our favour on direct discrimination, the reasoning of the Court of Appeal is really not illuminating at all on indirect discrimination. It simply won't assist this court in analysing indirect discrimination. My lords and my lady, that's what I wanted to say on indirect discrimination, there are two other matters that I wanted briefly to address, and I may not finish it tonight, but I will certainly finish it within the allocated time early tomorrow morning. The first topic concerns the consequences of the Court of Appeal decision if it were to be correct. I'm sorry, my Lord, there was one other matter I need to deal with before I turn to that. There are three other matters that I need to deal with. The first other matter that I need to deal with is that reliance has been placed by E on the fact that since the judgment of the Court of Appeal, a religious practice test has been adopted and applied by the United Synagogue, by JFS and by other schools. I need to deal with that. I deal with it in this way. The religious practice test has been adopted most reluctantly because the judgment of the Court of Appeal gave us no alternative. The judgment of the Court of Appeal decided that to adopt any test based on membership of the Jewish faith, that is, whether you are Jewish according to the United Synagogue, Masorti, Reform, Liberal, is a breach of the Race Relations Act. And it was simply not open to us, in the light of the Court of Appeal decision, to say we will adopt a different test, one that recognises, for example, that the oversubscription criteria should extend to persons who are recognised to be Jewish both by the Orthodox community and by the Masortian Liberals and Reform, because the direct discrimination approach of the Court of Appeal excludes all of those synagogues. They all apply, as I indicated this morning, they all apply a test based either on dissent or on conversion. So a difficult question arose: what oversubscription criteria should now be adopted for entry into schools in September 2010? And that's an urgent question because of statutory obligations to publish the admissions criteria, an important, difficult question at a time when this appeal was pending.
I didn't get very much guidance, I'm bound to say, from the page 745 you showed us. This is the
No, my Lord, well, I'm coming to what
There's not a great deal of detail in there, but you have shown us evidence, I think, about the problem trying to adopt a test based on practice gives rise to. I mean, there are orthodox rules which make it very difficult, as I understand it, to have a test depending on the frequency of attendance at synagogues.
Well, that's the evidence before the court. The evidence now before the court comes in two forms. It's evidence that has been produced by the United Synagogue. Yes. In the witness statement of Mr. Jacobs, which the court has, and there's also evidence from the Board of Deputies, including a statement from Mr. Benjamin. Yes, I'm grateful to Mr. Wolfson. It's entitled Submissions to Accompany the Case for the First Intervener, and I'm not going to take the court through all of that. Before I attempt to sum up...
You mentioned two items. What was the first?
The first was the evidence of Mr. Jacobs,
Where
Mr.
do we
Jeremy
find
Jacobs. That is loose. I'm grateful. I'm told it's behind the case for the third intervener, the United Synagogue. If your lordship doesn't have it there... I haven't got it in mind. Yeah. No. If your lordship doesn't have it there, the other of your lordships and ladies
we do have it there.
It's a witness statement of Mr. Jeremy Jacobs.
No, I've got it.
I'm very much obliged. Now, can I make...
I don't know whether your lordship and ladies are aware that we have objected to this evidence.
On grounds
It came in last
Came
week.
in very late,
It came
yes.
last week, it's
Yes.
contentious,
Yes.
and we have no resources or funding to rebut it.
Can I explain the position? Our case, I emphasise, is not if the court is against us on all the arguments I have advanced so far, that the court should find in our favour on indirect discrimination because of the practical difficulties. That is not my case. However, I am anxious that the court should not be under the misapprehension that it is an easy thing for the United Synagogue to adopt a religious practice test, or that a religious practice test is somehow consistent with the principles of Orthodox Judaism. My friend says she's had no chance to answer this material, which of course is correct. However, it is a response to her own printed case, which relies expressly on the fact that a religious practice test was introduced following the Court of Appeal judgment. And the only purpose of this material, as I understand it, it doesn't come from us, but the only purpose, and my friend Mr. Jaffe and my friend Mr. Wolfson may wish to mention it when they come to make their submissions, is to ensure that the court understands that the religious practice test has been introduced very much under protest, and it is causing very real practical difficulties, and it is entirely inconsistent with the doctrine of Judaism, which is not based, as the court has seen already, is not based on belief or faith. And Judaism, as my Lord Hope has indicated, hopefully, is very much a religion, the observance or practice of which takes place not in a synagogue, but takes place in the home. It's a question of, for those who are observant, it's a question of lighting candles on the Friday night, not eating unkosher meat, observing festivals. It's very difficult to assess observance without intruding into people's lives. And that's what the material addresses. I thought it right to mention it, but I emphasise again, my case is not that we can justify for indirect discrimination purposes by reference to practical difficulties. My case on indirect discrimination is as I've advanced it this afternoon, and your lordships have my points, and your ladyship have my points in relation to that. But I do ask the court, when you have the opportunity to do so, to read that evidence and to see the practical problems that the approach of the Court of Appeal has introduced by requiring a Jewish faith school that is an Orthodox school to adopt criteria that are inconsistent with fundamental principles of Judaism in order to try to accommodate what the court regarded as the requirements of the Race Relations Act. So I mentioned that. May I then turn to the two other matters that I wanted to address. The first of them is the consequences of the Court of Appeal decision, if it were to be correct in law. As I've mentioned already, if the Court of Appeal's approach is correct, then criteria for an oversubscription policy which focus on whether a child is Jewish according to the United Synagogue or the Masorti or the Reform or the Liberal, they're all equally unlawful. The illegality would apply whether the schools were funded by the local education authority or whether the school was privately funded. There would be no difference on the Court of Appeal's approach. We do submit that given that other religious groups are able to adopt oversubscription criteria that do not focus on belief of the child or indeed the practice of the parents. See, for example, the Catholic school, which gives preference to those children who were baptised, possibly some years earlier. An example is Appendix Part 2, page 579. It would mean that the law were distinguishing between Jewish faith schools and others in this vital respect. And we respectfully submit the court should be slow to arrive at a conclusion that Jewish faith schools cannot proceed by reference to factors other than religious practice or belief when other schools, such as the Catholic school, may. But there are other consequences of the Court of Appeal judgment which we attempt to deal with in our printed case. I could invite the court's attention, please, to paragraph 77, where we suggest that if the court, this is at the bottom of page 68 of our printed case, the consequences of the Court of Appeal's judgment, if correct, paragraph 77, would also extend into other areas. And that's because, my lord, my lady, if the Court of Appeal's approach is correct, then it is always unlawful, subject to specific statutory exceptions under the 76 Act. It's always going to be unlawful to confer a benefit on those who are recognised to be Jewish by the chief rabbi or by the religious authorities of the Masorti Reform or Liberal synagogues. And we give an example at subparagraph 2 of the person who offers his services through a religious organisation to teach about Jewish religious law in evening classes and charges a fee for doing that. There's no doubt he would be offering his services to a section of the public, so he's within the scope of the Race Relations Act. And if that's right, he simply cannot confine his services, these classes, to Orthodox Jews or Jews who are recognised by the Reform Synagogue, Liberal synagogues, or the Masorti Synagogue. On the Court of Appeal's approach, this would be unlawful. It is striking that it would be unlawful when Parliament in the Equality Act has very carefully addressed precisely this sort of problem. Could I ask the court, please, to go to volume 9 to look at the Equality Act at tab 71, because your lordship and your ladyship will see in the Equality Act how carefully Parliament has addressed these matters. Parliament has made it unlawful for a person to discriminate on religious grounds in the provision of goods, facilities and services. That's section 46 at page 34. But there's a general defence, general exception, at page 44, section 57. Section 57 is a defence based on organisations relating to religion or belief. The section applies to an organisation the purpose of which is to practice a religion of belief, advance a religion of belief, teach the practice or principles of religion or belief, enable persons of a religion or belief to receive any benefit, engage in any activity. And 3, nothing in this part shall make it unlawful for an organisation to which the section applies, or anyone acting on behalf of or under the auspices of an organisation to which the section applies. That applies to the man who's providing the evening classes under the auspices of the synagogue. To restrict membership of the organisation, to restrict participation in activities on its behalf or under its auspices, to restrict the provision of goods, facilities and services in the course of activities undertaken by the organisation on its behalf or under its auspices. Parliament has carefully considered precisely the sort of case that I refer to and recognised that it is necessary for obvious reasons to ensure a statutory defence which simply would not avail the man giving or the woman giving the religious instruction if the Race Relations Act would otherwise be breached. One could give many other examples.
I'm sorry, so that this religious teacher would be obliged to teach Whoever is prepared to pay his fee?
Yes.
And why is that such a problem?
Well, because he wants to provide, and the United Synagogue want to provide facilities and services as the Equality Act recognises they may, pursuant to Section 57. We want to provide it to members of the organisation, that is the United Synagogue, or to confine it to people who are Jewish. Perfectly proper, says Parliament, for goods, facilities and services to be provided under the auspices of a religious organisation to persons who are classified by reference to their religion. And these careful provisions recognising the limits to religious discrimination would not avail the United Synagogue in its activities for members if a complaint could be brought under the Race Relations Act. That's the point. And many other examples could be given. It's no answer for E to say, as he does, that the Race Relations Act allows for exceptions where appropriate. The point is that there are no relevant exceptions in the Race Relations Act, no doubt because Parliament did not envisage that discrimination of the sort we're here concerned with would pose difficulties other than ones that could be addressed under Section 57 of the Equality Act. And my point is simply to suggest to the court that one should be very careful here about bringing within the Race Relations Act matters of religion which are addressed by Parliament under the Equality Act. The other matter, the other supplementary point I wanted to mention is human rights law. I will deal with that very briefly indeed, but your Lordship's ladyship may think it more appropriate for me to deal with that.
Start with that tomorrow morning.
I'm very much
My Lord, can I, before your Lordship's rise,
yes.
can I just respectfully hand up 7 pages of material? Your Lordship has seen material which sets out the views of the various Jewish denominations prior to the Court of Appeal's decision. There are 7 pages which we'd like, on behalf of the Board of Deputies, and with the consent, I understand it's of all the parties, and particularly that of the respondent, to hand up. So your Lordship has a flavour of the views of the community post the Court of Appeal decision. Perhaps I can do that through the usual channels.
Yes, thank you very much.
Read this on my BlackBerry, but I'm assuming you don't object to it.
Never switch.